this is Court Watch with Alex Swoyer, and I'm excited to bring you the latest episode of my podcast where I am joined by two court-watching experts with different ideological perspectives. Curt Levey from the Committee for Justice and Elliot Mincberg from People for the American Way. They'll both highlight some of the key cases worth monitoring this term. The justices return to the bench the first week of October and will issue a lengthy orders list where they could decide to take up disputes involving the abortion pill and its FDA approval, diversity admission policies at the high school level, and state laws out of Florida and Texas that crack down on social media companies and censorship. But so far, several of the cases already granted review by the justices examine the reach of the administrative state. It gives the court a chance to crack down on the reach of the executive branch. First, I spoke to Curt, who shared with me some of the cases he thinks could be a blow to the feds. Hey, Curt, thanks so much for joining us. In a prior email, you and I had talked about the theme possibly of the term, at least so far, being in relation to the administrative state. So I wanted to ask you what cases in that, looking at it from that focus, that you have, had your attention focused on surrounding what will be, I guess, this coming week. We have one already, the CFPB, right?
Yes. And I guess just to set the scene, most people expect this to be a big year for administrative law cases, expect the court to take a bite out of the administrative state, curb its overreach. And people think that not only because the court has already granted, three big administrative law cases, but also because, probably the biggest victories for conservatives last year were in administrative law cases. You had three big victories. I guess I should quickly set the background. You had the student debt cases, where the court said the education department had stretched the HEROES Act beyond, recognition when it granted the massive debt cancellation. You had Sackett v. EPA, in which the court narrowed the EPA's virtually limitless definition of wetlands that could regulate under the Clean Water Act. And then you had Exxon v. FTC, in which the court said you can challenge the constitutionality of the structure of the FTC before a final judgment from them, before being dragged through in-house proceedings that can drag on for years. And two of those three were unanimous. So it's, the court definitely seems, even the liberals, to be suspicious of the ever-growing administrative law state. I'll put in a plug for my organization, the Committee for Justice. We filed amicus briefs in all three of those big wins last year. But so I think it's that momentum from the last term that people are looking at in assuming that these administrative law cases are going to go, likely to go the conservative way. Mm-hmm. And, one of them is, as you said, the CFPB case, in which it's basically just a challenge to a rule, regulating the payday loan industry. But more importantly, it's a challenge to how the CFPB gets its funding. It gets it from the Federal Reserve, and the argument is that violates the Appropriations Clause, which says that basically, funds have to be drawn from the U.S. Treasury. Mm-hmm. They can't be drawn from, in this case, the Federal Reserve.
Right. The idea that Congress should be appropriating this every year versus the director going in perpetuity to the Fed for money that the director sees fit, right?
Yes. It was set up that way precisely to try to bypass Congress. And the argument is that you can't do that the Constitution intends for Congress to be the appropriator. Then you have the Loper-Bright case. You have fishing companies that are challenging the National Marine Fisheries Service regulation that requires companies not only to have federal monitors on board, but to pay for those federal monitors.
I think it was in the past, some of the different, I guess it depended on exactly, I don't know, what fish, I don't know exactly, some type of specificity that the feds were paying, but then it changed, the rule then I guess changed so the fishermen had to pay, which obviously if you're a small business, that's a big deal.
Yes, and I don't remember the exact amount of money, but
I think it's like $700 a day. I saw one figure said like it could drop profits by 20%.
So you can understand why they're motivated to challenge it, but there's a much bigger issue at stake. The cert petition to the Supreme Court had two questions. One, whether this particular regulation was lawfully enacted, but then also the larger question of whether the court should overrule Chevron, which is a almost 40-year-old doctrine that basically tells the courts to defer to agency interpretations. Now, normally the court would sort of take the narrower question of whether the regulation was lawful and not reach such a big question as whether Chevron should be overruled. But in this case, they did the opposite. So that suggests that, it takes 4 justices to grant cert, that there's at least 4 justices who want to overrule Chevron and, probably more than that.
Yeah. So that 1984 Chevron case, I guess, like, at least in law school, I remember I was taught if the law is specific, like if there's ambiguity or if it's unclear, then the agency head, when implementing the law passed by Congress or the federal rule, they kind of get to shape in the way that they interpret. And so courts have just deferred to that rather than striking down, I guess, what some of these rulemaking bodies are doing.
Yes. And I mean, Congress has a bad habit of passing ambiguous statutes, and the ever-growing administrative state is happy to jump in and fill that void and basically act as legislatures. And they were getting very little oversight from the courts. And if they do overrule Chevron, that's really going to make a big change. That's not to say that federal agencies won't continue to be the interpreters of statutes. It's just they'll be subject to a little more scrutiny by the courts.
You also mentioned one other case that deals with the administrative state, and I thought I hadn't really been tracking it, but I think it's very interesting. I don't know if I'm going to pronounce it right, but is it the Jaseski case?
I think it's Jarchese, but a lot of people are pronouncing it in various different ways. But anyway, it's SEC v. Jarchese, and again, the facts are it's a hedge fund manager who the SEC found committed securities fraud in in-house proceeding. That is, not in Article 3 courts, but just, within the agency's own administrative proceedings. And Jarchese challenged, basically the structure of the SEC, saying that these in-house enforcement proceedings violate the constitutional right to a jury trial, the Seventh Amendment right, and also that when Congress shielded the administrative law judges that do these proceedings from removal by the president, that violates the separation of powers because, of course, these agencies are part of the executive branch headed by the president. And that Axon case that I mentioned earlier, that sort of cleared the way for these sort of, for people to challenge the structure of these agencies. So you're going to see more of these challenges, I think, regardless of how this case goes. And if they were to, say that the in-house proceedings violate the Seventh Amendment, that would be a huge blow to all these independent agencies and perhaps the non-independent ones at all. The SEC, the FTC, the FCC. They all have in-house proceedings that arguably violate the Seventh Amendment right to a jury trial.
And we don't know exactly when this case is argued, right? Have they set a date yet?
Trying to think.
I haven't noticed that one. I
don't remember a date. As you said, the CFPB case is the second day of the term, but yeah, I don't remember dates for those other.
I don't
two.
know if we have them yet. I've been trying to keep track. I know they've released the first 2 sittings, and I don't recall those. I know the CFPB, like we mentioned, and then of course there's an interesting gun case I'm sure you're focused on, which will be in November. But I guess maybe that's the segue to the next topic, away from the administrative state. Are there any other major disputes that you think we should be paying attention to?
Well, certainly the gun case that you mentioned, and that involves a federal law that prohibits you from having a gun if you have a domestic violence restraining order, and the case involves a gentleman who threw his girlfriend to the ground and dragged her, and a Texas court issued a restraining order and reminded him that he was not allowed to own a gun because of it, and he argued that he made a Second Amendment argument before the Fifth Circuit and originally lost, but then you had the Bruin case which came along, which basically told courts that in evaluating Second Amendment arguments, they should look to history. Mm-hmm. What would be, what types of regulations of guns were historically allowed, at the time that the Second Amendment was enacted. And because of that, the Fifth Circuit looked at this case again and said that, the domestic violence statute did not have a good sort of parallel
foundation. Right.
Exactly. And so they ruled for Rahimi, and the Biden administration quickly asked the Supreme Court to take the case up. They agreed. Rahimi argued that they shouldn't take the case, that it was very early on in the sort of process of the lower courts sorting out exactly what Bruin meant, and that the Supreme Court should wait for more lower courts to sort of work out the historical doctrine. But Supreme Court disagreed with Rahimi, and it took the case, and we'll see what happens. But I think even though it has only been a short time, the lower courts are struggling with applying this historical standard. And they do need more guidance from the Supreme Court, and they'll get some from this case. I don't expect the Supreme Court to, sort of do all the work for the lower courts here. They'll probably, issue a fairly narrow ruling, and we'll somewhat have to guess at what it means for, other gun control statutes. But I think it will provide some guidance. So I think it's a good thing that the court is agreed to take this case.
You and I talked about, I think, previously how this ruling, the Bruin decision, came down telling lower courts, to look, if a gun control law stands, it has to have some sort of historical precedent or foundation. And we talked about how there's been like hundreds of, I think, court decisions since then where it looks like lower courts are kind of grappling with how to apply that, like not just with this domestic violence issue, but also like, I think it was like drug charges. There also seems to be mention of this case with immigration status and gun ownership or possessing a firearm. So it's an interesting area. We'll have to see what the court does.
Yeah, I mean, the Biden administration, a lot of this comes down to sort of, when you're looking for historical precedent, sort of what the resolution should be. Certainly there were no, laws 200 years ago saying you couldn't possess a gun if you had a domestic violence restraining order. But the, Biden administration wants to take sort of a larger view, and they say that the government, has a long history of, banning guns, for people who pose a threat to the safety of others. And that, in that sense, this falls, within the historical tradition. So, I guess one of the things we'll get out of the decision will be sort of what the resolution should be. Do you look at it very specifically, or do you look at the, a broader view that it's about, statutes that pose a threat to, statutes about people who, pose a threat to the safety of others. So in any case, I think it'll be an interesting decision. I think gun advocates are a little bit worried about sort of the political correctness of the domestic violence issue, that, some of the justices, may be afraid of, seeming like they're not tough enough on domestic violence. And so, this may be, there's an old saying about, bad facts make bad law. And Rahimi seems to be a bad guy. So that may make for bad law here. We'll see.
Right. You mentioned when we previously talked, there were some interesting First Amendment cases too. Can you mention those briefly?
Sure. One is the Vidal case, in which, I don't know if people remember, but in the 2016 presidential debates, Marco Rubio said that Donald Trump had small hands. There was a big national debate over what it means to have small hands. But in any case, a guy, Steve Elster, tried to register a trademark for the phrase "Trump too small," so that he could sell, T-shirts and things like that. And the trademark statute says that you can't have a trademark based on the name of a living person unless you get that person's permission. So they denied.
I don't think Trump probably said, okay.
Well, no, yes, exactly. I'm sure Elster did not ask for permission. But then the Federal Circuit ruled that, to the extent that, that the statute does ban this trademark, that was a violation of the First Amendment because, criticizing Trump is clearly protected by the First Amendment. And the court said that, the government just doesn't have really a big interest in, restricting, trademarks that are critical of government officials. And so Elster won, and the Biden administration, which, sort of has the obligation to defend the actions of the Patent and Trademark Office, asked the Supreme Court to review the decision, and they are going to review it. So, both this case and the next one I'm going to talk about involve the First Amendment in, sort of at the, as I said to you, sort of at the heart of the culture war issues. I mean, this involves, criticism of Trump, and the next one involves, social media, what, can and cannot be banned on social media. And there's two cases there. One is the Ladke case, and the Linke case, and the other is O'Connor Ratcliffe v. Garnier, and they're similar. Starting with Ladke, there's a guy, James Freed, who he originally had like a normal Facebook page, and then when he wanted to have more than 5,000 followers, he converted it into one of these public pages where anyone can follow. And Ladke followed, and when Freed became city manager of a city in Michigan, Ladke began to criticize him for how he was handling the pandemic, and Freed deleted those comments and ultimately blocked Linke. So Linke sued under the 1983 statute for a violation of his First Amendment rights, and the district court ruled for Freed that he could block Linke, and then the Sixth Circuit affirmed that. But then you got sort of the opposite result in the Garnier case. The Garniers were parents of children in the Poway School District in San Diego, near to where I used to live. And they, the Garniers, were posting comments critical of the trustees on the school board, and they had posted pages, I think it was on both Facebook and Twitter, for their school board campaigns, and then they continued to use those after they were elected. And again, they began to delete the comments by the Garniers and eventually block the Garniers. So again, very similar to the other case. But there you got the opposite result. The district court ruled for the Garniers, and I guess mostly ruled for the Garniers. They found that the school board members had qualified immunity from monetary damages, and the Ninth Circuit affirmed that. So you had a circuit split, and just basically comes down to. I should point out that the Sixth Circuit, ruled in favor of Freed because they said, his account wasn't part of his job. His Facebook account wasn't part of his job. Mm-hmm. So the question really is, if it was, if a government agency had an official page and they blocked people, then I think that'd be a clear First Amendment violation. But here you're talking about individuals who have accounts that they're using, that they've created on their own. In the case of Freed, that they use for, personal stuff as well as for work. But in any case, they're not official websites of any government entity. And the question is, are they nonetheless acting as state actors? Is there state action such that the First Amendment comes into play? And we will find out.
Wasn't this an issue with Trump too? I remember covering a few court cases that dealt with him blocking people, right? Like Twitter. Yeah,
there was that case in which Trump lost in the lower courts. Mm-hmm. The people expected the Supreme Court to grant review, but then Trump lost the election, and so the Supreme Court told the lower courts to dismiss. But the fact that the court almost took that, sort of indicated that they would quickly find other cases to decide this issue, and they've done that. And when the Supreme Court told the lower courts to dismiss, I remember Justice Thomas wrote an opinion in which he, said that the court really needs to sort of deal with how we're going to apply, First Amendment principles developed before we had these digital platforms, how we're going to apply them to these new platforms. And, Thomas said the court's, going to have no choice. It's going to eventually have to address this. And, how do we treat these private platforms that are, sort of functioning as as the nation's, infrastructure at this point?
Yeah, like kind of the new public square.
Yeah. And, Thomas was right. The court is going to have to address it. They're going to address it here, and they may address it in the Texas and Florida cases that haven't been granted cert yet, but which probably will, in which there were laws restricting the degree to which social media could
censor,
basically censor
right.
content.
Let me ask you on that same topic. The Texas law obviously dealt with the Fifth Circuit. You mentioned like circuit splits, right? But I'm going to kind of point to the Fifth Circuit because we have that social media law that has been, we don't know if the court's going to hear it or not, but Texas passing a law restricting social media companies from what they can, I guess, define as like hate speech, what they can censor. And then you have the gun case you mentioned with the domestic violence dispute, CFPB. I'm going to butcher the name again, but is it Jarkessi? What'd you say? The one with SEC?
I think it's Jarkessi.
Yeah, Jarkessi. That, and then the abortion pill appeal, like over whether or not it was out of the Fifth Circuit and a Texas federal district court on the FDA approval over the abortion pill that's now on appeal from the Biden administration to the Supreme Court. We'll see if they take that. All of this deals with the Fifth Circuit. What do we make of that? Like, it seems like there's a lot of cases from that area this term.
Yeah, well, the Fifth Circuit is the most conservative of all the circuits at this point. And, it's sort of providing a service to the nation in that it's, I would say courageously taking positions that are correct. Other people might say that it's, would probably say it's, a right-wing court that's coming up with outrageous rulings. But whichever of those two you believe, it's creating circuit splits. And the Supreme Court is, much more likely to take an issue if there's a circuit split. So I think the Fifth Circuit, whether you love it or hate it, is providing a service to the nation. I mean, these are all important issues that the court should hear. And, maybe the court's not crazy about addressing them, but the Fifth Circuit is, sort of forcing the Supreme Court to address them. And I think that's a good thing. Mm-hmm. These circuit courts, change over time and, given a number of years of Democratic appointments. It may be that the Fifth Circuit is not always the most conservative circuit, but I think, right now, most of the interesting cases seem to be coming out of the Fifth Circuit.
Right. They do change over time. I know we had the Ninth Circuit super liberal, and then Trump was able to get a lot of appointments there. And so it's kind of it's still very liberal, but, it's changed some of those 3 judge panels. It can change the outcome for sure. I just want to say you've been very generous with your time. Thank you so much, Curt. I appreciate the rundown, and I'll have to have you back, to talk to me about what we make of some of these arguments after they happen, and if we think the court will go any sort of way.
Happy to do it, and thank you so much for having me on.
Also, during this episode, I caught up with Elliot Mincberg, Senior Fellow at People for the American Way, who joined me to discuss what legal battles his organization is tracking. I really appreciate you taking time to do this
Sure.
and kind of break down what the big cases are that you've been watching this term. I know that there's a number of them, but if you can kind of give me maybe your top 5, that would be great.
Mm-hmm.
I know you mentioned, and this is one of the ones we've talked about in previous stories that I've written and you've weighed in on, is the Rahimi case, the gun one. I think it's going to be November 7th that we hear the arguments on that. Can you tell me a little bit about that? And if you do think that we're going to see the Supreme Court clarify the Bruen holding at all?
Well, it's a very important decision because it relates to whether or not the federal law that prohibits gun possession by people with domestic violence restraining orders against them is valid. And clearly there's going to be some clarification of Bruen at the very least, because the question is, how will the court apply the historical test that it's set up in this instance? We've seen a number of lower court decisions that have frankly gone both ways. Some Trump judges have used Bruen to make it harder to have valid gun safety legislation. On the other hand, some Biden judges, despite Bruen, have upheld important gun safety legislation in Illinois, for example. So it's a big question which way the court will go in this case. And it's extremely important for gun violence and gun safety across the country.
Right. And one of the things people focus on the domestic violence angle with Rahimi, but they also, he was, you can correct me if I'm wrong, I don't think he was convicted yet, but he had a series of shootings, right? Across Texas.
Right. And there was the important thing is that there was a restraining order issued against him. Mm-hmm. And that is the basis under the federal law for saying you shouldn't have a gun under those circumstances, because you're a danger to someone potentially in your household.
I know I saw one amici from a women's shelter out of Houston saying that some of the abusers had been contacting some of the women or their clients following the Bruen decision, and how it's been intimidating and threatening. So it's going to be a very interesting case to follow, especially to see what the court does. But even the arguments, I think, will be lively. Agreed. What are some of the other ones that I should be paying attention to?
Well, some of the other ones that we're following, one of them on which there's some news indirectly today is the issue of redistricting, in this case in South Carolina, the Alexander case. A 3-judge court ruled that the Republicans had improperly done a racial gerrymander of a House district in the Charleston area, and the Supreme Court is going to review that. Now, just this morning, the Supreme Court, we think, in a positive way, declined an attempt by Alabama to further delay a court order affirmed by the Supreme Court, directing it to draw a second majority black district in Alabama. Put together, these two cases are extremely important for minority voting rights, and also could have a significant impact on whether the Democrats can take the House back in 2024.
Mm-hmm. And that the Alabama case you mentioned, we talked about last term. So that was GOP lawmakers basically went to the Supreme Court and said, petitioned that they had, I think it was like one majority black district. The lower courts had said based on the population they needed two. The Supreme Court agreed in light of, I think it's Section 2 of the Voting Rights Act, that they should have a second majority black district, remanded the case, and then they went back again, and they've, I guess, doubled down, you could say.
Yes, it's a classic example of massive resistance, frankly, by the state of Alabama. They were attempting to see if they could get Justice Kavanaugh to change his vote. He was the fifth, clearly, in the 5-4 decision that went against them. In this one-line order, not a single judge dissented. I think even the conservatives on the Supreme Court lost patience with Alabama's efforts at delay.
So I remember, I think it was like earlier this month, the state said that, I guess, the lower court, which issued it, maybe it was like September 5th, that the wording of the lower court was very interesting. They said, like, they were pretty shocked that the lawmakers did this, and said, ordered a special master to go ahead and draw the map, since the lawmakers weren't, I guess, following the previous ruling from the Supreme Court. And so the lawmakers had said, we need you to step in here so the special master doesn't draw it. But it looks like the special master will.
Yes, the special master has already submitted several plans. There's going to be another hearing on it. It's expected by October, on deadline, that the district will be drawn, and that will allow, for the first time in history, a second majority black district, thereby recognizing the increased population and voting strength of African Americans in Alabama. Another civil rights case that we're following is the Atchison Hotel case, which is very important on the ability to use testers to enforce civil rights law. A black and a white couple, both similar in income and other respects, to apply for the same apartment. And if it turns out that the white couple is accepted and the black couple is rejected, that's pretty good evidence there's some discrimination going on, and a lawsuit can be filed. What the courts have held before, including the Supreme Court, is that a tester can bring a lawsuit even if the tester doesn't really intend to, in that case, rent the apartment. The case before the Supreme Court has to do with a tester with respect to disabilities who is suing a hotel. And again, the question is, what will the court do? Hopefully it will not rule that testers do not have standing to sue, because that would incredibly severely limit the ability to enforce a whole range of civil rights statutes.
And they added to that, I think, whether this case, that's what the issue was, but they also have added, I think, to decide if it's moot or not, because it does have odd facts, doesn't it? Like the plaintiff has been involved in a few. She's been involved in a few lawsuits.
The facts of the case are very odd, and it would be possible to rule against the tester without creating the kind of harm that we're concerned about. But that's the real reason we're following it.
For some of our listeners that might not know what I'm referencing, it's one of her attorneys was sanctioned because I think he's appealing that, obviously, but a judge had said he was filing so many of these cases with this plaintiff that there was no way she was going to be able to go everywhere. And that, what was it? Wasn't it like something to that effect?
Something to that effect. So, and again, we in no way defend the conduct of the attorney. We're not taking a position on it, but the issue is, will the court rule that testers don't have standing, and that could be disastrous in a range of civil rights areas.
And I know the tester in this case, I think she had asked the court not to hear the case because of that. I think there was some concern about what would happen with the attorney issue there.
I think that's right.
Yeah, so we'll see what they do.
Then one other area that we are following very closely are a number of cases relating to the ability of federal agencies to protect our health and safety, led by the Loper case, where the court is being asked to overturn the longstanding Chevron doctrine that gives some deference to administrative agencies in interpreting ambiguous statutes and rules that they administer.
That's the one that deals with the fishermen and the daily rate.
That's right. The real concern that we have is that the court uses it as an opportunity to throw out the doctrine, even though it was one that was firmly supported by Justice Scalia, of all people, a number of years ago, and makes it much easier for right-wing lower courts to second-guess and throw out agency rules and actions that help protect our health and safety.
Would you agree with the court taking, it looks like, this case and kind of administrative state cases? I think you're probably going to also reference the CFPB and what's at stake there, right?
Yep. No, you have two other cases that are high on our list. One of them, as you just said, relates to the Consumer Financial Protection Bureau and whether its method of funding violates the Constitution. If it does, not only could that jeopardize the CFPB and other agencies with similar funding like the Federal Reserve, it could jeopardize the validity of actions of the CFPB for a number of years in the past. So that's an important case also on administrative law issues.
I want to make sure I get in some of the cert petitions too, but I want to, before we go to that, is there any other ones that I need to be focusing on that you guys
I think those are the major ones that we are focusing on. There's certainly other cases that we're going to be watching closely and many that the court hasn't taken yet. Yeah,
well, that's what I wanted to get into. There are some very interesting cert petitions, of course. One is the abortion pill. And that's
that's very crucial. What the Supreme Court did, another Trump lower court judge, Kaczmarek, essentially overruled the FDA's approval decades ago of the abortion pill, potentially harming millions of women across the country. The Supreme Court put a stay on that ruling pending the Fifth Circuit review of it, but the Fifth Circuit recently issued a decision that partly upholds Kaczmarek's ruling and said that the abortion pill approval cannot apply to telemed or to women a bit later in pregnancy, which again could harm countless women across the country.
Yeah, so I remember, I think the Fifth Circuit ruling, it didn't go as far as Kaczmarek to say that it shouldn't have never been given FDA approval back in the 90s. I think it was the two issues that you mentioned is being able to distribute it by mail, right? Like the telemedicine aspect, and then also limiting the amount of weeks that it's able to be prescribed.
Exactly correct. And this also has some impact on what we talked about before, second-guessing administrative agencies. But more importantly, it could seriously harm reproductive rights of millions of women across the country if the court either upholds what the Fifth Circuit does or, as it could do, goes back and upholds the original Kaczmarek decision. So we're very much hoping, as has been petitioned to the court, that it now takes this case again and issues a ruling on it, which will be, if it happens, one of the major rulings of the term.
Absolutely. And it'll be interesting to see like another abortion case. They tend, I think the justices like to try to take these hot button topics, like spread them out over a few terms, but it seems like we're getting guns, abortion, race relations a lot.
I think that particularly with respect to reproductive rights and gun safety, the far right just won't quit and is continuing to push until it gets everything it wants or thinks that it can. And if the court thought that what it did in Dobbs or Bruin would tamp that down, they were wrong, because more of these cases are continuing to come up.
I'm going to ask you about social media stuff too, which I don't know if it clearly has a left and right divide. It seems like some people, conservatives have been more critical of social media companies in the past, but Texas had passed a law basically related to what the companies could define as, I guess, hate speech or censor, that sort of thing. Florida did one similar, and it had to do with not being able to deplatform politicians.
Yep.
Both of those are on appeal to the Supreme Court, have cert petitions pending. I guess a lot of people are watching this because, of course, it deals with the First Amendment. There's been talk about like how the social media, even though these are private companies, it's like the new public square. I guess what do you make of this? Do you think they're going to hear this?
Well, I think it's hard not to, partly because the lower courts are split on this issue. One of the statutes was upheld, and one of the statutes was struck down on First Amendment grounds. And the efforts by some states, like Texas and Florida, to restrict what really are private actors' ability to control what's on its platform is already a very serious First Amendment violation that I think both some conservatives as well as progressives are concerned about. As you're suggesting, there are some right-wing advocates who maintain that this is all just a big liberal plot to control the media, and we want to be able to control what those media do, even though they're private. It would be like going in and telling a newspaper what op-eds from other people it can run or not run, and hopefully the court will take the cases and try to put some consistency into how that issue is dealt with. So again, that could be a potentially major case that doesn't have quite the same usual ideological implications.
And so the Texas one is out of the Fifth Circuit. The abortion pill petition is out of the Fifth Circuit. The gun case we talked about, the domestic violence, out of the Fifth Circuit. You mentioned this in an email to me previously. I guess the CFPB case too. I've talked to other court watchers about what they make of this, but what do you make? What do you think about the Fifth Circuit kind of rocking the docket?
Yeah, well, I think it reflects the fact that the Fifth Circuit, which is dominated by far right and Trump appointed judges, seems to be as a whole even further to the right than the Supreme Court is on some of these issues. We've seen some of that already. And their decisions, many of them, effectively have nationwide impact. The abortion pill decision, for example, applies everywhere, not just in the Fifth Circuit. So it's not a surprise that these issues come up to the Supreme Court. And what's interesting is that at least in some of them, and we'll see about the ones up this term, the court has ruled, sometimes by a close majority, that the Fifth Circuit has gone too far and too fast. Mm-hmm. We hope they will do that again on these cases this term. But on the other hand, it's quite possible with the 6-3 court majority that there will be a majority to uphold these very damaging Fifth Circuit decisions.
Do you think it relates to forum shopping?
Oh, absolutely. There's no question that that relates not only to the Court of Appeals, but more importantly to the district courts. Because of how spread out some of the states in the district court are, you can effectively, and because of the rules of some of the local courts, you can effectively almost guarantee which judge you'll get depending on where you file. So a lot of right-wing advocates and states like Texas have been filing cases in Lubbock, for example, because the judge there is Matthew Kacsmaryk, one of the furthest to the right judges that Trump had nominated. And there are some in Louisiana and other places as well where the districts are set up that you can basically not just shop for them, but judge shop. Mm-hmm. And that's very damaging. There are some proposals to actually change that in Congress, which I hope they consider. But in the meantime, if you're able to shop for a judge in the Fifth Circuit, and you know you're going to have the Fifth Circuit reviewing that judge's decision, that's golden for far-right advocates.
Right. It used to be, I guess, like the Fifth Circuit for conservatives, the Ninth Circuit for the liberal advocates, but I guess the Ninth Circuit, after Trump's appointees, it kind of depends, I guess, nowadays. It used to be the Ninth Circuit that was getting reviewed all the time by this court.
Well, and I think they still are to a certain extent. But part of that also reflects the fact that you don't have a Trump administration issuing very bad decisions. Instead, you have the Biden administration doing progressive policies, which the far right is determined that the place to do that is Lubbock, Texas, and other places in the Fifth Circuit.
Because what you're referring to, I remember, I was going to say, not to interrupt, but like when Trump administration was in, you saw a lot of California, Washington State, Oregon. A lot of them their AGs were leading lawsuits that, of course, are in the Ninth Circuit, challenging federal policy.
And that's certainly understandable. Again, one of the big differences is that it wasn't quite possible to judge shop the way the right wing is able to do today, because you filed in San Francisco or some other place, and you couldn't tell for sure which district judge you're going to get. Here and now, because of the situation we've discussed before, you can almost guarantee you will get a very far right district judge along with the Fifth Circuit to review the case.
Mm-hmm. Before I let you go, is there anything else that I didn't ask you that I should have? Any other case we didn't talk about?
Well, there's several other cases that are important. There's a tax case. There's a case about whether the SEC can do administrative hearings on certain issues, but I think we've covered the major ones.
Mm-hmm. Well, thank you so much for your time. You've been very generous. And then, of course, I'd love to have you back once we get some of these arguments done and we can kind of like see if we have any predictions on which way the court will go.
Absolutely, will do.
Thanks for tuning in to the latest episode of Court Watch. I'll have another episode in the coming weeks breaking down the court's recent arguments and what type of rulings we may see by the end of the term, which usually wraps up in June. If you have not subscribed yet to this podcast, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.